And people see them and call them the raper boy them. It was difficult for them to get work. It was difficult to go to the supermarket. It was difficult to do anything.
Welcome to Stuck, exploring wrongful convictions in Jamaica. I am your host, Andrew Wiles. In today's episode, we're talking to attorney at law Lambert Johnson. When I started reading about wrongful convictions, one of the things that made me a bit uncomfortable was when I started to read about the role of defense lawyers in contributing to wrongful convictions. And if we are going to be honest, we have to talk about everybody's role in the system. It's easy to talk about how the police mess up and how the prosecutors must do better and what we want from judges, but we are not being honest and we're not improving the system if we don't talk about how sometimes the person who does the most to send an innocent person to jail may be their own lawyer. In the first episode of Stuck, Unfair Games Played Twice, we looked at the story of the Brissett brothers, two young men from St. James who were accused of one of the worst crimes in Jamaica's history. And they were immediately denied the presumption of innocence. Nobody believed them. The public was outraged. And while that's to be expected, one group of people who wanted nothing to do with them were defense lawyers in their parish. Eventually, one lawyer stepped forward and took up the challenge. That lawyer, Lambert Johnson, is our guest today on Stuck. He's a very accomplished attorney, past president of the Cornwall Bar Association. He's represented clients in a number of high-profile matters. In our conversation, we talk about a lot of things, including his work as a criminal defense lawyer, where he gets his passion from. But we also discuss the amazing fact that after 10 years, the Brissett brothers are still fighting for justice. They are still fighting to be compensated by the government of Jamaica. By the way, if you have not yet subscribed to Stuck, please go ahead and subscribe. What are you waiting for? And also share it with your friends. If there's anything you don't fully understand or you want to see more of, I read the comments and I would love to hear from you. What has happened since the brothers were acquitted and where are we now?
Since the brothers were acquitted, we have filed a suit against the Attorney General, essentially the government. It's a claim for damages for false imprisonment and malicious prosecution. Surprisingly, the Attorney General's department has thought it fit to vigorously challenge the claim. And so we have gone through the preliminaries of having mediation that did not work and case management conference, and the matter is now set for trial sometime in 2026. I don't recall the date offhand. But in addition to that, what a lot of persons would not know is about a year after, based on the DNA evidence, the real perpetrator was caught and he was tried in the Western Regional Government Court. In fact, he pleaded guilty and he was given a term of 35 years for his actions. A lot of persons are not aware of that. Surprisingly, after the young men were acquitted, persons would ask, how do I do? Did I do it? Do you have any friends in high places? Did I have someone who made up the DNA results for me to get the kind of results that I had? And I said, no, it came from the heart of the government institution. They were the ones who took the blood. They were the ones who tested it. It wasn't done from our side. It was done internally by the government. And there are still persons who were doubtful and still thought they were guilty.
Wow. That is one of the things that people have been asking about the obligation that the DPP's office was under after they got the results. I guess that would feed into perhaps also why the government is defending the claim. It seems to me that even among attorneys, but just generally, people are not very clear as to what the government's obligation is when DNA excludes somebody.
And so that created quite the storm, I remember, because this was a truly high-profile case. It's one of those cases that gripped the nation. And so because of what was happening, because of the anger that surrounded the case, the judges hesitated in giving bail. I remember there was one particular judge, I made the application and she said that she will consider it, but I had to come back the following week. But then it turned out that she was not going to be there the following week because she just did not want to touch it. And so there are a lot of persons who avoided the case. I suspected, from what I'm now finding out, I might have been the 6th or 7th attorney who was approached on this matter. And there were several persons, even other attorneys, who said to me, why am I taking up this nasty case? And when I was asked that question, my reply was, what if they are innocent? Is there not one amongst us to defend them? What if they are innocent? And so that is how I got to that part. And so because of the difficulty in getting bail, they were in custody for several months. It finally dawned on me and I suggested to them, I said, gentlemen, only way you're going to escape this nightmare is to do a DNA test. And they said, yes, we will do it. We'll do it. You know, they were overjoyed because here was a chance. I sat them down and I explained to them that if the results came back positive, the only option they had at that point would be to plead guilty because I could not be of any other assistance. And they said, no, Mr. Johnson, we are sure. And the DNA test was done. And when the results came, it was like a bombshell. I don't remember who it was, but I remembered some hesitancy on the part of the prosecutor at the time to agree with me that the results were exculpatory. They were trying to go around it, and I like, it is there. And then the judge who was presiding, he was resolute and sure as to what should happen, because even then, the prosecution was objecting to bail. And the judge said, no way, they must get bail. And that is how they were able to get bail. While they were on bail, they had to literally stay indoors because there were still threats surrounding them, and people would see them and call them the raper boy them. It was difficult for them to get work. It was difficult to go to the supermarket. It was difficult to do anything. Even though they were on bail, they were in captivity at their own home for their own safety. That's how it was.
This matter was gun court, so there is only so much that we as a public can read and know for ourselves. What is it that led exactly to the matter? Meaning, is it that witnesses testified and then it was brought to a doc ID and they were not able to point out the men? That's what transpired, correct?
No, so in the trial, when they were asked to point out the persons who committed the various assaults, they did not point out the men. They just did not point them out. Because by then, having heard that that vindicated the men, it would take a very, very brave soul to then come to court and say, I'm sure this is the person. Because what they'd be doing, if and when the real perpetrator is caught, you could not then at that point change your evidence. He said, no man, it's not that man who I sent to prison before, it is this man. It just doesn't work that way. And I'm happy for the advent of DNA evidence. It has the potential to send persons to prison, so be it. It has the potential to cause convictions, so be it. But what I like most about it, that it has the potential to ensure that innocent men and women are not convicted unnecessarily.
We talk about the prosecution, right?
Yes.
And the prosecution has a lot, I think, to answer in terms of that case. Even since looking at it, I've had to go back and look at what the Privy Council has said about DNA evidence and how it should apply, where it includes, where it excludes, where it's absent. And that is something that, I think it's clear. And I think it's clear what should have happened in your case, right?
Yes.
But the defense, I don't know if we have ever really, as a bar, processed what it meant for the defense to be hesitant about defending these two young men. I saw the Chief Justice, he wasn't Chief Justice at the time, he did a presentation called Defending the Devil, and he talked about the first case he selected was the Irwin case to talk about it. I don't know if we have really come to appreciate that the defense has a role to play as well in ensuring that people are not wrongfully convicted. I saw even years after that, you had to respond again where a pastor was talking about defense counsel not taking up certain cases. Do you think that despite Irwin, this message is lost, or do you think that people have come to see based on that case that, we have to take defense work seriously?
I'll go further, because one of the things persons out there sometimes believe in jungle justice, and they will take the law into their hand, and they'll be literally judge, jury, and most importantly, executioner. And then it turns out in some cases that the person who has literally been executed and has been hung to the cross is innocent, never participated. And it is always that fear for me that the innocent man will suffer for something that he never did. But what they should also realize is the real culprit is out there waiting to pounce and to do the act. So it is always to my mind, you have to make sure that due process is followed. I am a firm believer in due process. It might be long, but without it, innocent persons will be made to suffer. I've seen it happen over and over.
Another thing that stands out to me as you're talking is that their trial happened. They were arrested the same week of the incident.
Yes.
Right? But for them to get now to a point of compensation, they're saying a trial is in 2026.
And just to refresh you, the incident took place in 2013. So 13 years later, they are still not being compensated. And what I can tell you, I have information, reliable information, I'm able to get the proof of it, that initially the police knew that these were the wrong persons. And part of what comforted me taking this case is when I read the file, it was clear. If somebody was to step back, it was clear that these were not the men, because the description, and this I remember clearly, they said both men were had low haircut. They had recently gone to the barber. But when I saw them, they had in cane row, substantial cane row. And this was like within 4 days of them being arrested. So they wouldn't have been able to get that kind of facility while in custody. No one here grows that fast, but no one was prepared to look at that one fact, because I am told that when the men were placed on ID parades, pictures of them were shown, because I know of persons who complain bitterly that police will go to your home if they want you, and they will seek to either get you an ID or a photograph of the accused man. And so sometimes it is distressing, it is amazing that they do this. They will get pictures of persons and put it to the witnesses to ensure that someone is pointed out. The reality is the local detectives who were assigned were of a different view from the imported detectives from Kingston. So they sent, it was being investigated, I think, by a detective sergeant. They sent a detective inspector, and he was being supervised by the superintendent. And of course, I'm just imagining you had the commissioner of police and maybe the minister of national security looking over their shoulders, because this was a matter that when it first occurred, persons demonstrated in the middle of the town in Sam Sharp Square that whosoever did it must be brought to justice.
Right.
And it is what it is.
No, but and that is a part of it, because to look at how the Patrick Green was apprehended, it was just people in the community, right? And that is a lesson that has just been lost on us, that they import these people to think that they have all the solutions, and then the case goes off the rails and they go back somewhere else, when perhaps if they had taken the time. Because I've looked at the news reports, and I saw that first the news was reporting that the men were identified on the ID parade, but then when you took over the case and you made that first application for bail, you pointed out that the ID parade, the description that was given didn't match the men, and that was there in the press, right? And so from that early point, you could see that something is off with this case, right? That's long before DNA came out. You made that first point, and it was recorded. So it brings me to this other issue. I don't know how much you can speak on it because the matter is before the court, but with compromise ID evidence, let me frame it better, because clearly the ID was an issue. Clearly the DNA was an issue. How is it that the government is opposing settlement? Why are you being asked to go to a trial? Or I mean, I don't know how better to frame it. You're right.
You have asked it properly, but to this day, I remain mystified, and I'm not a person easily mystified, because the facts are there, plain to see. Because there are many persons, and I always go back to this, there are many persons who are on death row in the States or across the world, and then with the advent of DNA, some tests are done, and it is clear that this person was wrongly accused, and they might have spent 20, 30, 40 years in custody, and they are released. So if it is DNA evidence, scientific evidence is regarded as being so positive, as being so convincing, that's the word, convincing, because remember, DNA says, and I've never seen it less, there's a 99.99% chance, and it goes on and ad infinitum, because they don't want to say, I'm sure this is a person, so they give you a mathematical probability, or this is one person in 7 billion, and there's only 7 billion persons in the world, and sometimes they give you probabilities that exceed the population of the world, and you're like, oh, you're really saying that this is the man? But their protocol, they don't really say this is the person for sure. They just say that on a mathematical basis, you're 99% sure. 99% is just shy of 100%. Just shy of 100%.
I guess the last thing I would ask you is, in terms of accountability, to your knowledge, has anyone ever been held accountable for anything in this case? I knew that after they were acquitted, there were calls by groups for investigation into the matter. A group had raised the issue of the pictures being circulated, and Commissioner Ellington had said that he would have a probe. I haven't been able to find anything publicly to say that anyone has ever said, what happened in Irwin? How did we get this wrong? What it sounds to me is that they are still defending what happened in Irwin.
Oh, yes, they are.
The DPP defended it at the time, and it seems that there has been no accountability, and there is no intention based on the civil defense for there to be any sort of accountability.
It pains my heart, but what can I say? It's a position they have taken, and I just have to prepare myself so that when we get into court, we can ensure that justice is done in respect of this civil aspect of this matter. Because this happened when they were young men. They are forever scarred, and they will never live it down. Never. The memories, they were beaten, whilst they were in custody, they were left in circumstances where they were assaulted by other prisoners. But the police feel that, having regard to the horrific nature of the crime, they were entitled to do so. Well, so be it. We have sued, and we are hoping that the compensation that is given will be adequate, not only to compensate them, but to show the aggravated nature of what was done, and to send a message to investigators that when you investigate, do it properly. Don't do anything that is improper or has the potential to lead to an injustice.
So Johnson, thank you very much for taking the time. Really, I plan to follow this case. I plan to follow this case until the end, because I think it is so important. I think that a part of why these things happen is because we allow them to die. And I have seen you and watch you with a lot of admiration stand up to the forces. It was a lot of forces that were against you. And those two young men needed a strong advocate. And I really appreciate and respect how you represented in that case. And so I definitely plan to continue to observe until the end and to share to whoever will listen about this case. So thank you very much.
Yes, before I go, because what I remember, when I was in law school, the gown that we wear in the circuit court has a tab to the back. And historically, what it meant was that those persons in the 16th and 17th centuries, when they were in the dock and a barrister is in front of them, they were entitled, because there's a pouch on it, to put the fees of the barrister in it. And then when that is done, they were obliged to represent them. Because as we say in Jamaica, it's not about looking in faces. It's about looking at the case and what are the merits and demerits and take it from there. Yes. All right. So it was a pleasure speaking with you. I wish you all the best, and if needed, we will speak again.
All right. Thank you so much, Sir Lambert. That was my conversation with Lambert Johnson. I hope that you enjoyed it. I hope that it got you thinking. If there is something that stood out to you that, I don't know, maybe you never like it, maybe you disagree with it, maybe you say yes, maybe you have a personal experience, let me know in the comments. I read them, I respond to them, and I would love to hear from you. Until next time, I'm Andrew Wiles, and this is Stuck. Hey, thanks for listening. Stuck is written and presented by me, Andrew Wiles. It is brought to you by The Wave on the Frequency Network. Subscribe to Stuck wherever you get your podcasts. You can read more about the project at andrewwiles.com. And if you found the conversation interesting or helpful, share it. Thanks for tuning in. Until next time.